This conference will now be recorded.
Hello, and welcome to Constitution Day, September 17th, 2018. So today we're going to talk about the milieu in which the Constitution was created, why, essentially, and what was going on in the world. We'll specifically break down the articles, which is the meat, and even some of the details in those articles, known as clauses. If we have time, we'll cover some amendments and interpretations as well. So the milieu. We're all familiar with 1776, but there's this confusion that somehow 1776 and the Constitution are connected or related. They're not. Totally different. So from 1776, we get the Declaration of Independence, which it's important to point out is not a binding document. It's a letter sent to King George over in England. And then the government then that declares its independence, right? By definition, once those colonies have declared independence, they constitute the new government. So the Second Continental Congress is the first government of the United States. As you probably know, most of these meetings all happened in Independence Hall, what we call now Independence Hall. The first Continental Congress actually happened down the street at the Carpenter's Hall, but the Second Continental Congress, the Articles of Confederation Congress, and the Constitutional Convention all happened in what then was called the state capitol, and now we call Independence Hall. That's the room. It's magical. If you've been there, you can't but feel the history that happened in that room. I direct your attention to the back, to the presider's chair or president's chair. There's a sunburst on the backing of that chair. And famously, Benjamin Franklin said about that sunburst, is that a rising sun or a setting sun? As I said, the first government of the United States was that Second Continental Congress that declared itself to be independent. During the course of the war, they managed the war. Towards the very end of the war, they created a new government, our second government, which is known as the Articles government. The presiding or the unifying document is called the Articles of Confederation. They did three things, incredible things. They signed the Treaty of Paris, ending the war. They did the Northwest Ordinance, and they also did the Land Ordinance, right? 1785, I believe. But that government, it was clear that the states had too much power, that the federal or national, they didn't even call it a federal government then, the national government was too weak. The other issue was that in Congress, each state only had one vote. So there were 13 votes. You needed 9 votes to pass any piece of legislation, which is a pretty high percentage. It's 67%. The other thing is in order to change the government, and this will come up later in the presentation, you needed to have unanimous consent, 13 out of 13. Ultimately, they decided this isn't working. Let's reform the Articles government. That's an important term. They were going to reform the Articles government. And so they met in Philadelphia in 1787, and it's what we call now the Constitutional Convention. And here they wrote out, they debated, having a stronger national government, creating a federal government instead of more of a confederation that the Articles government had been. And, it was controversial. It took them a while to get it passed and then longer to get it ratified. It did become law in 1789. Here's the signing of it. I was one of the delegates. I'm a little older than I look, and that's me on the right side, trying to just get to the bottom of what's best for this great country. Notice again the president's chair or the presider's chair in the back with the sunburst. So, as I said, the meat and potatoes of the Constitution are the articles. Prior to the articles is the preamble. That's the part you probably know. We, the people of the United States, in order to form a more perfect union, blah, 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 blah. And then there are a bunch of articles. The most important ones are the first 3. First and foremost, you have to choose somebody to go first, right? So the founders and the writers of the Constitution, Article 1, by definition, is the most important article. Article 1 is the legislative branch. Therefore, the founding fathers want the legislative branch to be the most powerful branch. Nowadays, I think most of us would say that the president is the most important branch, but the third branch, the judicial, is the one branch that can outrank the other two nowadays because of judicial review. So in Article 1, that lays out the House of Representatives and the U.S. Senate. There's a picture of me from when I was working for the House of Representatives. The guy I worked for was Jack Reed, 2nd District, Rhode Island, who's now in the Senate. So it's kind of cool. In the House, they laid out the, what the representation was, the qualifications. You have to be 25 years old and to have been a citizen of the United States for X number of years. But here's a theme I want to point out. The Constitution is not perfect. So many people talk about the Constitution as if it's the be-all, end-all word of God or something. It has the famous 3/5 clause in Article 1, right? The idea that African Americans are only 3/5 of a human being. How could we say that the document that says an African American is 3/5 of a human being and that Native Americans don't even count at all, how can we say that that is somehow this inviolable, perfect document? It's not. It's just a document made by man. Power of the purse is an important theme in legislative process. All revenue bills, taxation bills have to come out of the House. It's just the way it is. Now, we have 535 total members of Congress. 435 of them are in the House. That is a legislative cap. They could make more if they want. Right now, a single seat in Congress is representing about 600 to 650,000 people. When I was young, again, I told you I was old. I went back to the founding fathers, right? No, but when I was working in Congress, one seat was 400,000 people. So that's a huge change just in my lifetime. The Senate also, this theme that I want to point out, the document is wonderful, but not perfect. The Senate was created to, yes, we know that all the states are equal in the Senate, 2 and 2 for each, but they also originally wanted indirect elections. They didn't like the idea of average people having too much power. And so they built in the Senate as being an indirect election where wealthy people and politically connected people could block popular desires. That didn't change until the 1900s with the 17th Amendment. And then there's this famous filibuster rule, which is not in the Constitution, which the tradition is it goes back about 140 years or so. And as you know, it was a big deal last year, 2017, it was changed so that the filibuster rule does not apply to SCOTUS, but does apply still to legislation. One of the most confusing things about the Senate and about Article 1 is that the Vice President of the United States, the VP, is the President of the Senate. So the one guy, Mike Pence in this case, in 2018, he has 2 titles. He is the Vice President of the United States and he's the President of the Senate. So within Article 1, there's a bunch of stuff in there. I pulled out what I thought you'd be most interested in and or what is the most important. The most important line in probably the entire Constitution, but it's certainly in Article 1, is called the Commerce Clause. We nicknamed it the Elastic Clause because it stretches the power of Congress, that Congress can really do anything as so long as it relates to interstate commerce. But some of the things that I think, again, are questionable about how our government operates today is, the Constitution says only Congress can coin money, yet we have Bitcoin. The Constitution says only the post office has the right to interstate mail, right? UPS and FedEx. And while there's no problem with them moving packages, there is a significant constitutional question about whether they can do those 24-hour envelopes that are the shape of letters. That should be the purview only of the post office. For our purposes here as an art college, the fact that patents exist, that you have the right to protect your creations, your writings, your discoveries. In the Constitution, it says for a limited time, but it never defines limited time, which I'll come up on another slide, maybe next or two, to talk about a little bit more. But I just also want to throw this out too. Constitutionally, there has to be a census every 10 years. Well, a census is just how many people there are, right? For years, the Census Bureau has been adding more and more and more questions. Typically, it's been conservatives that have said, whoa, 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 there's no reason to ask those questions because you're only supposed to, constitutionally speaking, ask how many people there are. Now it's flipped. The Trump administration has added the question, is this person a citizen? And it's the liberal groups that are complaining that that's an unfair question to add on to the consensus or the census. So what I'm trying to get across here is that the Constitution, again, is not static, that it evolves over time. And some of the things that we use and we toss around the word constitutional, well, it's really not what the original intent or the founding fathers meant. And similarly speaking, the founding fathers, again, were not necessarily always right. I do not think that indirect elections in the Senate or not counting Native Americans or counting African Americans only as 3/5 of a human being, there's no way I think those are legitimate. The document is just a document. It's a beautiful document, but it's a living document that has evolved over time. Here's the actual language of the patents. To promote the progress of science and useful arts by securing limited time to the authors, inventors, the exclusive right to their respective writings and discoveries. That's what copyright is all about. Here you can see how it was legislatively enacted over time, and the Sonny Bono Act, the Mickey Mouse Act, is the most controversial. It went up to the Supreme Court. I believe it was RBG that wrote the decision, and I totally disagree with her decision. They made the argument that any legislation is by definition a limitation. My argument and the argument of the plaintiffs is that by continuing to extend the limitation, you in essence are violating the Constitution because it's never going to end. Mickey Mouse, sadly, should expire. He should become public domain. Meanwhile, that's a lot on the first branch of government in the Article 1. What is going on in Article 2? Article 2 is the presidency. One of the terms that's controversial and indefinable, undefined, is this idea of natural born citizen. What is a natural born citizen? We've always assumed it means that you're born in the United States. However, if you were born in another country and you are naturalized, you've passed the citizenship test. The term for passing a citizenship test is to be naturalized. So then would you not be a natural born citizen? That's the argument. And then there's the question about what constitutes in the United States or not. John McCain ran for president of the United States, and he was born in the Panama Canal Zone. At that time, it was considered to be part of the United States. But why not a U.S. military base in Germany? What's the difference? Or how about Mitt Romney? He ran for president, as you're aware. His father, you may or may not be aware, George Romney, ran for president. He had been the governor of Michigan, and he ran for president. He was not born in the United States. He was born in Mexico. However, his parents were both U.S. citizens. So he was, you got a natural born citizen. He was born by 2 U.S. citizens. He's natural born. So even though he was born in Mexico, he ran for president, although it was never contested because he didn't win the nomination or the presidency. And then in couple of recent elections, let's go to the second bullet point in terms of restrictions there. The Constitution says that president and vice president can't be from the same state. In 2000, the Republican ticket, Bush Cheney, both of them had filed state taxes in Texas the year that they ran for president. And so the question was whether that was legal or not, unconstitutional or not. Cheney amended his taxes and changed his residency to Wyoming, the state that he was originally representing in Congress. So they kind of got around that a little bit. And now the first bullet point, the foreign annulments clause, which nobody's ever read before, but because of President Trump, now all of a sudden everybody's a constitutional expert on foreign annulments. So that's Article 2. Article 3 is the judicial branch, the judiciary. All it does is say that there is a Supreme Court. It doesn't say that there are 9 seats. It says that has to be defined by Congress. It also talks about other courts established by Congress. it does go into a little bit of detail about original jurisdiction, who can go to the Supreme Court. It either has to appellate-wise work its way up to the Supreme Court, or if the case is between two states or between the United States and a foreign government, it can go directly to the Supreme Court. The Dependent Nations Clause, actually, it's not actually in the Constitution, but I put it there because that's the more established term. It comes actually out of Worcester versus Georgia, I think, or Cherokee versus Georgia, one of those two Cherokee cases. The idea being that Native Americans are only mentioned in the Constitution 3 times. And so it's clear because they said in the Commerce Clause, it says that Congress, that's back in Article 1, Congress has the right to regulate commerce between the states, the Indian tribes, and foreign powers. So clearly, according to the Founding Fathers, Native Americans were neither American nor foreign. There's some kind of in between. And John Marshall talked about them as being, quote unquote, dependent nations. Article 4, so we're out of the 3 branches of government. So we'll do these really quick, but I think that this is an important point. It's one of my pet peeves that always drove me nuts because the issue of gay marriage never should have had to go so long and progress all the way to the Supreme Court, because as soon as Massachusetts back, almost 20 years ago now, certainly more than 15 years ago, passed civil unions and eventually marriage. As soon as one state passed same-sex marriage, it became constitutional everywhere. And it just took the rest of the country about, like I said, 15 or 20 years to catch up to constitutional law. Let's put it this way. I got my first driver's license in Rhode Island. Okay. Then I moved to Pennsylvania. Then I moved to Ohio, then I moved to Kentucky, then I moved to Massachusetts, and finally I've moved to Colorado. I didn't have to take a new test, a new driver's test. Each state recognized the fact that the previous states had given me a driver's license. Similarly, think about this. You get married in one state. Heck, you get married in another country. You don't have to come to when you come to Colorado, you don't have to get remarried, right? Colorado recognizes the fact that you got married in, Nebraska, Wyoming, what have you. Contracts are recognized by every state. So therefore, a marriage contract is recognized by every state. So that's my little soapbox on Article 4. Article 5 is so exciting. It's the amendment process. Stay in your seats. Article 6 is interesting to me. The Supremacy Clause, people talk all the time about how treaties are not right or not legal. And, there's a lot of bashing of the UN and the NAFTA and the WTO and NATO and all kinds of stuff. That's NATO on the left of Superman and the UN on the right. The fact of the matter is the Constitution says that once a treaty is ratified by the United States Senate, it becomes, constitutionally speaking, the supreme law of the land, like the Constitution. So it's, again, another one of those kind of arguments made by people who have never actually read the Constitution. So let's go back. I talked about how there were 3 governments. There's the Second Continental Congress government, which created the Articles government, and then the Articles government that they wanted to reform. Key point, reform. This was the language that was used in it, and that's where it says that it has to be an agreement confirmed by the legislature of every state, unanimous consent to change the articles. So here we go. Here's the Constitution. Here's the endorsement page or section of the Constitution. Count with me. Delaware, Maryland, Virginia, North and South Carolina, Georgia, New Hampshire on the other side, Massachusetts below that, Connecticut, New York, New Jersey, Pennsylvania. Here's the problem. Those are only 12 states. How many states were there originally? There were 13. What's missing? Who's missing? Bingo, Waldo found it. It's Rhode Island. You're welcome, Rob Fladry. So Rhode Island did not sign the Constitution. So I'm going to go backwards. To change the articles, it has to be unanimous. Rhode Island didn't sign. Dun, dun, dun. You can actually make the argument the Constitution's illegal. But I'm not an anti-government conspiratorialist that wants to overthrow and start militias. So I just think it's funny. And I'm sharing. So what do I want you to do? I want you to love it. I want you to read it. I think we have some copies of the Constitution for you too. And if you have a couple more minutes, let's look at some of the amendments real quick. The amendments, the first 10 are called the Bill of Rights. We're all pretty familiar with speech, press, religion, petition, and assembly. I know the first three there, speech, press, and religion, get the most attention. But these, again, like I said, Article 1 is about the legislature on purpose. These are first on purpose. These 5 rights are the most important rights, according to the Founding Fathers. And the general issue here is that you have these rights until they interfere with somebody else's rights. The most famous limitation of speech is the Supreme Court case about you can't yell fire in a crowded theater. Yes, you have the right to say whatever you want, but the point when you yell fire in a crowded theater and it makes people panic and react, you've now violated their rights. Similarly, freedom of press. You have the right to print everything you want or whatever you want until it gets to the point of libel, right, where it hurts somebody else's right. Freedom of religion, and this is you know, they're all important, but this is such a big issue, and it's an issue that came up in the Colorado cake case, right? Masterpiece Cake versus the CCRC. What is the limitation between on somebody's freedom of religion? The current, I'm going to sidestep Masterpiece Case and go another famous example, religious decorations. The Supreme Court decided in Donnelly versus Lynch, you have the right to decorate public property for a religion as long as it's open to the decoration of every religion. If you're not open to every religion, then you can't decorate for any one. You know, that's what they're talking about, what's called the Establishment Clause. I digress. I could do First Amendment all day. Second Amendment, oddly enough, is not about the arms of bears. Apparently has something to do with guns and militias and stuff like that, and keeping and infringing and stuff like that. This is controversial enough. We're going to just keep on going. The Quartering Act is probably one of the most useless amendments because it doesn't apply anymore. It actually means that you can't force soldiers to, or you can't force people to house soldiers. Fourth Amendment is your right to protect yourself from search and seizure. And this is the whole point of having warrants and such. This is an issue right now in terms of the wiretapping of Roger Stone, I believe it was, in the Trump campaign, whether that was legal or not, because yes, they got a warrant, but the basis for the warrant was questionable, et cetera, et cetera. You got the Fifth Amendment, protection of against self-incrimination. The protection of double jeopardy. Those are the main things. You got Sixth Amendment, the idea that you have the right to a public trial, a speedy trial, to confront the witnesses against you, et cetera, which is fascinating, an issue in terms of, like, say, child abuse or sexual assault. It's one of those weaknesses in our legal system because the person accused of sexual assault or child abuse, they have the constitutional right to confront their witnesses. Conversely, if you're the victim of child abuse or sexual assault, is it fair to make you have to relive it all over again and or be in the same room and look at the person who did such horrible things to you? Sometimes they've gotten around this by doing videotape testimony and so forth, but it's an amazing constitutional issue. There's no easy solutions. Seventh Amendment is the right to a jury, which interestingly, and you can waive your right to the jury, but it can't be waived for you. Eighth Amendment, no excessive fines, which is, not that controversial. What becomes controversial is cruel and unusual punishment, right? This is really all about the death penalty. Although other states like Arizona and Michigan and stuff who have like boot camp prisons, that's an issue too. Is that cruel and unusual? In Arizona, they have outdoor prisons with tents. Is that cruel and unusual? These are the questions. Ninth Amendment is, hey, we've listed these 8 amendments where you have all of these fantastic rights. Hey, and so the Ninth Amendment is just, hey, pay attention. Just because we forgot to mention anything doesn't mean it doesn't exist. You have many more rights that we don't have time to mention here. That's the Ninth Amendment. And then finally, the 10th Amendment is what's called the Reservation Clause or states' rights, that those laws, rights, privileges, responsibilities that are within the Constitution. Anything not mentioned in the Constitution actually reverts back to the states as a state right. And that again is somewhat controversial. And the brilliance of the Constitution, if you don't mind me concluding with this point, is the fact that the founding fathers they built in so many contradictory statements, and this is one of them. On the one hand, you have the 10th Amendment reservation clause that says if we didn't say it, it belongs to the states. But conversely, remember we talked about the Commerce Clause being a catch-all. In fact, it's nicknamed the Elastic Clause because it can be stretched out and include everything. So the Commerce Clause and the Reservation Clause are almost completely contradictory and cancel each other out. And so different courts, different political parties favor one or the other. First and foremost is the term strict interpretation. Those strict interpreters are the ones that say, hey, take it literally. But we've already talked about there's contradictory statements. Typically, conservatives use strict interpretation. They rely heavily on original intent in the 10th Amendment. And then conversely, the other school of thought is called loose interpretation, typically aligned with political liberal parties. They favor the Commerce Clause and they favor federal authority over states' rights. That's what we got. This is the Constitution of the United States. It's beautiful. It's amazing. I hope you learned something, and thanks for paying attention.